I think we've talked about this in the past, but it kind of reminds me of the whole FACE Act issue, right? Where they have these federal laws that were, you know, capable of putting pro-life protesters in jail under federal law for upwards of a decade sometimes. And they were claiming, well, it's necessary to prevent, people from obstructing access to abortion clinics and all this, but or assaulting or obstructing workers at the abortion clinics from coming in and helping women get into the clinic. Like, there are already laws against assault, against trespass, against obstructing. Like, these already exist. This is clearly just an additional law to target pro-lifers, and I think that's the same thing here. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
Well, we are actually in the same physical location, so we figured we would try something a little different here. You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits, this time in person. So this week we have a couple of big legal cases that are making their way up through the courts that we wanted to cover, and then one policy note at the end. So we'll be covering a case that's in the 11th Circuit that enjoined a town from enforcing a buffer zone against sidewalk counselors near an abortion clinic. And then we'll turn to an appellate case in Minnesota that upheld the rights of Catholic schools to hire according to their faith. Then we'll finish with the recent cancellation of certain contracts for religious instruction assistants in the U.S. Army. So first two cases in particular there's a lot to cover, so let's jump in. So this is the 11th Circuit case. The two parties are the city of Clearwater, Florida on one side and Florida Preborn Resuce on the other. And this is one of these typical buffer zone situations, but with some interesting facts. So the city of Clearwater has this vehicular safety zone that they've enacted by ordinance, which prevents pedestrians from standing within this 38-foot stretch of it's kind of sidewalk. You actually have to see a picture to understand what's going on. But the public walkway includes the area right in front of that's actually at the edge of the driveway going into the clinic. So you basically imagine a sidewalk, and then the sidewalk ends because you have the driveway, and then you have the sidewalk pick back up. And so the stretch of sidewalk in front of the driveway, and then 5 feet on either side, is this buffer zone. The city's purported reason is vehicular safety, protecting both the pedestrians and the drivers who are coming in and out. And we'll get to the facts of that in a minute. But what happened was several members of Florida Preborn Resuce, which is a pro-life organization that does, sidewalk counseling, as well as some more general handing out literature. There are some protesters, I think, involved, but that's kind of separate from the people who are filing suit here. So because of this buffer zone, the sidewalk counselors at Florida Preborn are pretty much unable to do what they're supposed to do because, for one, they can't walk on the sidewalk area where people are driving or walking into the clinic. And for two, they can't go near enough to cars to either talk to the people who are driving into the clinic or give them literature, which pretty much destroys their whole ministry because almost everybody who goes into this clinic in this suburban neighborhood kind of area drives into the clinic. So they really can't access anybody. It's a pretty severe restriction on their speech as well as their religious exercise, although we'll get to that. They did go with the free speech argument moving this case forward. So they filed a lawsuit, asked the court to enjoin this ordinance from being enforced. The district court ruled against them based on a lot of precedent about buffer zones and an analysis that the 11th Circuit recently said was not done correctly at the district court level. So the update recently, I think just last week, was that the 11th Circuit ruled that the restricted zone prohibits substantially more speech than is necessary to promote the city's interest in upholding vehicular safety. Right. So there's an ability to have some kind of time, place, manner restrictions on speech, but they have to be basically narrowly tailored. The analysis is a little different because it's intermediate scrutiny, not strict scrutiny, but we'll get to that in just a moment. So the long and short of it is the court found that since the sidewalk counselors in this case were unable to give out leaflets to those entering the parking lot, unable to talk to people closely in an intimate way, basically they were relegated to standing behind a line and shouting at them, which hampers their free speech in an unconstitutional way. That's where the 11th Circuit ended up. So the case was sent back to the district court with instructions to put the injunction in place against enforcement of this ordinance. So, like I said, you have to actually look at the picture to fully understand how odd the the walkway situation is here. But the alleged reason for the ordinance is that the abortion provider said they've had regular issues with protesters, crossing the driveway of the health center, impeding cars from coming and going, getting within close proximity of driving cars with the intent to frighten and intimidate the vehicle occupants. That's the claim. I guess there's some video of people blocking cars. Allegedly, I haven't seen the video, just the court transcript here. But basically, so you have this public sidewalk. It crosses over their driveway entrance. The buffer zone keeps pedestrians out of that walkway area on business hours, Monday through Saturday. And in the process, the people like sidewalk counselors are really unable to exercise their free speech rights in talking to the women who are coming and going from these abortion clinics. So I think that one thing that's interesting in the factual record is that there was testimony from police officers at the district court level that admitted that enforcement of this is not neutral. The way that the ordinance is written, it's basically all pedestrian foot traffic, right? It's to keep vehicular safety. You can't have people walking in this 38-foot sphere during business hours because they're interfering with cars and it's dangerous, I guess. What the police have said is they would regularly cite pro-life protesters or sidewalk counselors for violating that 38-foot buffer zone. But if ordinary pedestrians were walking along the sidewalk and hit the buffer zone and were walking past it, they regularly just let them go without issue. So that's technically just as much a violation of the ordinance as when the pro-life counselors are on that sidewalk area, but it's clearly not being evenly enforced. So interesting to note, not surprising to note. Also, the 11th Circuit said that this is, and I think this is important. We've covered this in the past. We actually just covered it last week when we talked about the Olivier, the street preacher case that was at the Supreme Court the week before. So the 11th Circuit notes that sidewalks are exactly the type of public forum where free speech is meant to be protected, right? Same as we talked last week with the public parks. These are the kinds of areas where people are meant to be in the public square, able to talk about contested religious and political and cultural things when the First Amendment protection should be at its highest. Now, Florida Preborn here had several different arguments, but the one that went forward admits that this was content neutral, the ordinance, right? They didn't challenge it. They could have challenged it as applied and said, you're enforcing it unevenly because we're expressing a pro-life viewpoint, whereas the ordinary pedestrians are not, and so you're not enforcing it against them. So that as applied challenge would have carried a strict scrutiny analysis because it would have been a viewpoint biased restriction on speech. They did not pursue that. They pursued a new content neutral general. This whole law is a burden on constitutional rights, and so the level of scrutiny is intermediate scrutiny. They admitted that for their purposes they were challenging the law even if it's restricting content neutral in a content neutral way. So the test basically that they were left with was to decide, for one, is the law narrowly tailored to serve the a significant government interest and also leave open ample alternative channels of communication. So the 11th Circuit was pretty clear that this was not narrowly tailored and that really nothing less severe was considered at all. I'm going to read from the 11th Circuit opinion. So the court noted this restriction compromised petitioners' ability to initiate the close personal conversations that they view as essential to sidewalk counseling by making it difficult to identify patients before they enter the buffer zone, by making sidewalk counselors appear untrustworthy because they had to stand behind a painted border, and by reducing them to raising their voices at patients from outside the zone. So they really weren't able to communicate at all. It wasn't the most narrow way to ensure vehicular safety in this zone. The law makes it impossible to distribute literature at all because you can't get close enough to where the cars are driving because of the additional 5-foot buffer on either side of the driveway. So again, pro-lifers could really only stand behind a line and yell. They can't reach people in the cars. They can't really communicate with them at all. So clearly the ordinance burdens a key part of Florida Preborn's counselor's speech. So the question is whether the law burdens more speech than is necessary to promote the interest in vehicular safety. And it was pretty clear that it does. And this was interesting. The court found that the government here failed to consider less burdensome alternatives at all. There was no real conversation, which is a part of the Supreme Court precedent test in determining whether it's burdening more speech than is necessary, whether you've even considered alternatives. And in particular, the court reasons that existing ordinances that prevent people from soliciting or otherwise obstructing a motorway are actually sufficient to promote the safety that they're seeking here, right? If the idea is, well, we're only restricting access to this 38-foot area because we want to keep pedestrians safe. We especially want to keep the cars that are going in and out of this clinic safe and not being obstructed. There are already laws against obstruction. There are already laws against these kinds of behaviors. And it was interesting in the record, the city here argues that, well, the problem with those is those are just citations after the fact for obstructing traffic, or it's kind of hard to get someone for trespassing in this case because they're right on the edges of a public road, so it's probably not even trespassing. But even if we can get them and cite them for obstructing a vehicle or something, that's after the fact, right? We need to do something to stop them. And the court responded that this law is also after the fact, right? There's no barbed wire fence that's keeping people out of this 38-foot buffer zone. What happens is the pro-lifers, just like they can ignore the obstruction, general obstruction ordinances if they want, they can ignore this 38-foot buffer zone if they want. And so this isn't accomplishing any more to protect vehicular safety, and it's burdening more speech than is necessary. I think we've talked about this in the past, but it kind of reminds me of the whole FACE Act issue, right? Where they have these federal laws that were, capable of putting pro-life protesters in jail under federal law for upwards of a decade sometimes. And they were claiming, well, it's necessary to prevent, people from obstructing access to abortion clinics and all this, but or assaulting or obstructing workers at the abortion clinics from coming in and helping women get into the clinic. Like, there are already laws against assault, against trespass, against obstructing. Like, these already exist. This is clearly just an additional law to target pro-lifers. And I think that's the same thing here. And I think the court is pretty clear when they point out that there are already ordinances in place, and this additional buffer zone is a restriction on speech that doesn't actually accomplish any preventative thing, right? There's no fence. It's not doing much of anything. So, and I'll just end with this. One final note is, like I said, there were several challenges originally about both free speech and free exercise of religion. They went forward on the speech case. And I think this shows the continuing employment division versus Smith problem, right? That we see time and again, that the government can't restrict speech, right, without compelling interest and passing these high levels of scrutiny. However, and that applies even if it's a neutral law, right? Here, this is not an ordinance saying pro-lifers may not go in this buffer zone. It is neutral. It is generally applicable. In theory, it applies to all pedestrians, and yet it still can't burden speech unless it passes the scrutiny, the stricter intermediate scrutiny, depending on the case. Not true anymore since Smith of religious exercise, right? If this law is neutral and generally applicable, which it is, then you don't actually get the heightened scrutiny standard. And so it makes sense that they would pursue the free speech and not the free exercise claim here, because Smith has made it so that it is frankly easier for government to burden free exercise than it is to burden other rights like speech.
Yeah, absolutely. Frank, thanks for a great summary of what's going on there. And you alluded to this before, but I do want to add a little more color to the city's behavior in actually enforcing this ordinance. And it was noted in the circuit's opinion that the ordinance itself doesn't have any method for police officers to detain or arrest or anything like that. But cops were actually arresting sidewalk counselors for doing this. I don't know if any of them sentenced or anything, but they were going beyond actually what the law requires. And even further, it might be a little bit trite, but part of the city's defense of their statute here was that, oh, well, the sidewalk counselors are saying, well, we can't talk to people that want to talk to us anymore. They're saying, well, if somebody wants to talk to you that goes to the abortion clinic and parks, they could get out of their car and walk to you to talk. And again, it might be trite, but that would actually be a violation of the ordinance itself, because in order to approach these sidewalk counselors, they would have to walk across the vehicular safety zone. So if it really is about vehicle safety, they shouldn't say, well, you can just break it if you want to talk to people anyways.
Yeah.
Again, a very small detail there, but it does get a little bit to the animus of what's going on here. And really what happens here with these types of laws, and I think the city's behavior here shows this, is that it makes these pro-life sidewalk counselors look like bad guys. It makes them look like political protesters whose speech and conduct is so dangerous that they're not allowed to go near this specific area. Yeah. So it's painting them as protesters. It's painting them as dangerous. In order for them to be able to actually talk to anybody or get their attention, they have to shout at people, wave their arms, look kind of crazy. And the court notes that a waving hand is easier to ignore than an outstretched arm. So regardless of kind of the facial neutrality of the statute, both the way that it's carried out and its actual impact, it is very far from content neutral. Again, they didn't pursue that, but it does add a little bit of color of why these types of laws are so clearly problematic beyond even the kind of free speech issue. Yeah. So with that, we'll move into our second update, where we'll talk about a Minnesota appellate court's recent protection of a Catholic school's ability to hire according to its religious beliefs. So Holy Angels Academy is a Catholic school in Minnesota under the authority of the Archdiocese of St. Paul in Minneapolis. And a quick good corporate governance shout out here. In their bylaws, they actually say all of the school's activities are, quote, informed by and conducted in accordance with tenets of the Roman Catholic Church as determined by the Archbishop of the Archdiocese. So that'll come up later in this lawsuit, but way to go, you guys, for establishing your religious identity in your corporate documents.
That's
Love
right.
to see it. So the school was recently was sued for unlawful sex-based discrimination by its former librarian named Rezel Grace McCoride. So basically what happened here was the librarian, who is a man, after working at the school for a year, told the principal, I now identify as a transgender woman. And this was during the period where they were rehiring for the next year. So during that meeting where the librarian was saying that he is now a woman, the principal said, well, we have these guidelines from the Archdiocese that determine how we are to conduct how we are to interact with students regarding sexual identity and our kind of internal beliefs. Are you able to abide by that? After reading the guidelines, McClure said, no, I can't, because basically they say, quoting Genesis, that God created mankind in his own image, male and female, that sex is immutable, and that employees are to conduct themselves with students in a way that is in accordance with those beliefs and truths. So because of these very kind of traditionally Catholic and traditionally Christian beliefs on sex and gender, the librarian said, I can't abide by this, so I can't come back. He refused to resign, but then he just wasn't hired for the next year. After being not hired for the next year, he sued the school for unlawful sex discrimination under Minnesota law. So at the Minnesota trial court, McCoride lost, and the school, the case was dismissed at the trial level. I want to make sure I got my facts right. It was dismissed at the trial level, and that dismissal was recently upheld at the appellate level. And while there are some keynotes in interpretation we'll get into regarding kind of the implications of this case, the actual analysis here was a pretty straightforward church autonomy issue. McCorride's suit was really centered on the Archdiocese's guidelines. He was saying that these guidelines enable the school and actually call for the school to discriminate against me upon my sex. But the court observed that the First Amendment prohibits the judiciary from interfering here, because basically in order for the court to make a ruling, they'd have to decide on the validity of the Archdiocese's religious beliefs regarding sexual identity and gender, and their religious beliefs for requiring their employees to conduct themselves in this particular manner, which is very much grounded in the Archdiocese and subsequently the school's Catholic identity. So the actual legal analysis there was pretty straightforward. First Amendment says, and church autonomy says we can't interfere, because doing so would require us to weigh in on a doctrinal matter, which of course I'm not allowed to do. But there are 3 points kind of related to the legal question here that are worth spending a little bit more time on. The first is that there's this debate about the church autonomy doctrine as to whether it's an affirmative defense that can be invoked by a defendant kind of once a case has already begun, or it's more of a jurisdictional bar. It's kind of a standing question that says, can this person really begin their lawsuit in the first place? And in this case, the court treated church autonomy doctrine as more of a jurisdictional bar. They're saying before this case really proceeds at all, we have to weigh in on whether we can even hear this. And because of this First Amendment protection, we cannot weigh in on it. And that is a much stronger interpretation of the church autonomy doctrine than sometimes we see. Right? The case was dismissed for failure to state a claim upon which relief can be granted. So they're saying that this lawsuit never should proceed in the first place. The question the court that is really answering is whether or not this lawsuit get off the ground. And they're saying no. If it is an affirmative defense, then a court can start discovery. They can start kind of diving into some of the internal decisions of a religious organization, and then eventually they're stopped by this affirmative defense. But if it stops them in the first place, then that discovery never begins, then the burden never starts. A lot of times the process is the punishment. If CAT is treated as a jurisdictional bar, then the process never has to happen. Secondly, so the fact that this case is coming out of Minnesota, which has some kind of iffy non-discrimination laws for religious organizations, um, the fact that a Minnesota court ruled in this way with church autonomy shows that this is such an important defense, even when there are problematic state laws. Um, so in Minnesota, there are some protections for religious employers to hire according to their faith, but they are a little bit sparse. The best states will say that basically for the purposes of our non-discrimination employment laws, religious organizations are not employers, which just kind of exempts them categorically from all of these things. Minnesota doesn't say that. They do say that religious organizations are still subject to these laws. There are exemptions where basically if a Catholic school wants to hire Catholics, they can give preference to Catholic teachers. But importantly, also, that exemption doesn't apply to secular activities and roles, right? You could say the librarian isn't leading students in prayer, the librarian's not conducting any sort of ministerial role. There is a case to be made if this were to proceed on the merits that McCowright's position was purely secular, and thus the exemptions for religious organizations to hire according to their faith don't apply. So it is really important. While those state level laws are really important and still need a lot of attention, it's great to see CAD being invoked in a state that has some of these iffy laws and never letting this case proceed in the first place. And thirdly, I want to zoom in a little bit on the ministerial exception question that came up a bit at the end of this circuit court's opinion, or rather appellate court's opinion. I don't remember if it's a circuit is the name of the Minnesota court, but the second level court that was ruling here. So for those unfamiliar, the ministerial exemption is a principle from a couple of different Supreme Court cases. Most recently in 2020, it was strengthened in a case called Our Lady of Guadalupe. They're basically, the ministerial exemption says that a religious organization's ministers are not subject to state and federal non-discrimination laws. For example, in Our Lady of Guadalupe, the Supreme Court ruled that these two teachers that both, at least in part, taught religion qualified as ministers because they're performing an essential religious activity. As such, they weren't, the school that fired them wasn't subject to the non-discrimination laws that they were filing lawsuits against the school for, and thus the case was kind of thrown out. So here, the Minnesota court noted that the Supreme Court actually hasn't decided if a non-minister who is fired for purely religious reasons is also covered by the ministerial exception, right? You could say that this is a librarian, not really performing any religious duties. They're not maybe a minister under this exception, but they were fired for purely religious reasons. Are they covered by this exception? And the circuit court, the appellate court said, we're not really going to dive too much into this. They quoted Sonia Sotomayor's dissent in Our Lady of Guadalupe and said, we probably think that they wouldn't be covered. But regardless, any doubt surrounding that kind of question isn't sufficient to make church autonomy irrelevant in this case. So even if there is kind of this question of does ministerial exception apply here, the Minnesota court is saying even if there is kind of some cloudiness there, church autonomy doctrine can be applied otherwise and kind of bar this thing from beginning. So Frank, that's kind of what I've got. I'd love to hear your thoughts on this one.
Yeah, this is still this is an interesting area where there's been some developments on in the lower courts, and I'm curious to see whether a church autonomy case goes up to the Supreme Court in the next year or two. I think it probably will. One issue is the one you mentioned, whether the church autonomy doctrine itself is an affirmative defense that you bring up once a case is underway, or whether it's actually a jurisdictional bar, which would mean the courts don't have jurisdiction to hear cases that involve questions of church autonomy, and so you can't hear them from the beginning. No discovery, no evidence, right? Gone at the beginning. That's not an answered question. I think we have a circuit split. I know we definitely have split opinions, but I don't remember where the precedent lies on each side of that. But I think beyond that, there's kind of a tangled web here with the ministerial exception, the church autonomy doctrine, when they apply, how broadly we can make them work, and what laws they end up interfering with, right? So ministerial exception has to do with the hiring of ministers. So if you're cabining, these all flow from the First Amendment religion clauses, so there's a lot of overlap. But the ministerial exception applies to the hiring, firing, promotion, et cetera, of ministers, right? So it depends on what the definition of ministers is. Like you said, Our Lady of Guadalupe says it's clearly more than ordained clergymen. I think it was religious teachers in that case were considered ministers. So we don't quite know who is not a minister. We know it's broader than clergy. But again, to your point, if somebody's fired for religious reasons, but they are not a minister under the ministerial exception doctrine, we're probably not talking about ministerial exception. So then the question is, what are we left with, right, for church autonomy? And This is kind of complicated because the line of cases that we get that invoke church autonomy most of the time have been about internal understanding of governance and hierarchy, right? You have cases like Kedroff that are fights over often church property, and they often have involved the Russian churches because of the question of who is actually the lawful, like who is the governing authority that runs like a particular parish or particular diocese. Is it right the local bishop? Is it the people of the church? Is it the local pastor? Is it the metropolitan in Moscow? And that's when the courts really stepped in and said like you follow your own right hierarchical governance. Like the secular courts have no authority to step in and decide which church, right, which bishop, which governing authority within the church has proper jurisdiction to close a church, to fire it. Like that's not our place. So and then we've seen it expanded. We've seen church autonomy claims involving like fraud cases, right? Huntsman, that was a concurrence. But if there's a case where somebody alleges, oh, I was defrauded by the minister because he said he would do X with my tithing dollars, but he did Y, and some courts have said, well, again, church autonomy question: what is a tithe? What is a proper purpose of a tithe? What is your duty to tithe to your church? Not going there. That's a question for churches, for religious organizations to make, and not for secular courts. But here we get into something a little bit different because the court isn't actually being asked to decide an internal matter of church or religious organization governance, right, or internal operations, because it's not, and this is tricky, right? They're not, the courts aren't saying it doesn't matter what your church believes because your theology is wrong about transgenderism or about male and female. He created them, right? It's not so much that they're being asked to judge the validity of a belief, but whether they can hire based on that belief when it conflicts with state non-discrimination law. And so whether you can pull church autonomy that far to say that it gives churches or religious organizations the right to make hiring and firing decisions regardless of non-discrimination laws, that again, that's outside the ministerial exception, and that's interesting territory. I there my kind of gut instinct and my limited understanding in this area is that there has to be some First Amendment vehicle to say that religious organizations are allowed to hire according to their religious faith, notwithstanding overreaching non-discrimination laws. But I don't think we've quite found an answer to what that looks like and under which doctrine and how far you're going to take the church autonomy doctrine in particular. So we'll be following this one. I'm curious to see if it go. I think this one's pretty much dead now, right? With the appellate court
Yeah.
rejecting it.
The librarian is saying he might consider appealing, but I don't really see a whole lot coming out of this from here.
But if not, there are other cases like it. Like we saw the one in Virginia against Liberty University that was similar fact pattern, right? We saw Billard a couple of years ago with the substitute teacher, and they always resolve at different points and are decided on different doctrines. But it would be really interesting to see if we really get a straight First Amendment versus state non-discrimination law case that could be decided on the merits and to see where that goes. Um, all right. Now, in the interest of time, we're going to quickly cover one last one this is not legally heavy, so this will be a quicker topic. But there was some recent media coverage. The U.S. Army has faced criticism after canceling contracts that supported religious activities for soldiers and for the families of soldiers. So this happened sometime in November. The Army canceled contracts that were staffing a variety of positions that would support Catholic liturgies and education. They were basically support roles for the chaplains. Who are severely understaffed, by the way. So there were these trained catechists. The abbreviations are CREs and CPLCs, who would have these supporting roles, who would teach soldiers' children and assist the Catholic chaplains with liturgy. So it's liturgy and it's education for Catholics and their families on base, on post. So a lot of these contracts were canceled. There were some really important statements that have come out. Archbishop Brolio, who is the archbishop for the military archdiocese, noted that many service members, first of all, who are stationed abroad, often in environments hostile to Christianity, they don't have any alternative. So critics who are saying, like, why are we spending money on these catechists? Like, they can just go to the local parish. Like, really? Like the local parish if they're in Iraq or China, right? Maybe not so easy. But there's more than that. So the Army has defended this by saying, well, we have other roles. One of them are called DREs, Directors of Religious Education, and then RAS, Religious Affairs Specialists. And the Army's statement has said that, oh, they assured the Archbishop that, well, these DREs and Religious Affairs Specialists will fill many of these positions, assisting chaplains and catechizing and doing these educational and liturgical roles. And Archbishop Rolio in his statement points out, listen, for one, the DREs, the Directors of Religious Education, among the whole Army, there are only like 8 that are Catholic out of, what is it, 100 and something? So it's like less than 10% of them are even Catholic. The Religious Affairs Specialist is an operational role that doesn't even require you having any religious faith. So it's like to say, oh, well, they'll assist with liturgies, they'll catechize Catholic children on base. Like they're not Catholics. Like that doesn't make any sense. And Archbishop Rolio actually said, like, positing this is scandalous to say, oh, we'll get these, possibly atheist religious affairs specialists and they'll catechize Catholics on base. Don't worry. Yeah, that doesn't work. Also, Archbishop Berlio points out this is really alarming, actually, that how underrepresented Army Catholics are among Army chaplains. It is very hard. So, just for context, right, Army chaplains you need priests to give the sacraments, right? So, for Protestants, you can have ministers who are more varied in their level of education ministry, but you need a priest, right, to say mass and to hear confessions and to give the sacraments. So and also, as many of our listeners probably know, there are priest shortages in various dioceses. Usually, chaplains in the archdiocese of the military are on loan. They're ordained priests for a diocese, and they go into the army and do a stint as chaplains. So it's very hard to get already short-staffed dioceses, their bishops to give army chaplains over. So there are a lot of reasons going on, but the effect is that about 5.5% of the chaplain corps in the U.S. military are Catholic priests, but about 26% of the Army is Catholic. So the effect is you have about one chaplain for every 1,000 Catholic soldiers, let alone plus their families on bases, right? So Protestants, on the other hand, I think it's about 6 times that. I think there are about 6 chaplains for every 1,000 Protestant soldiers. So there are shortages. These supporting roles are really important to make sure that catechesis can happen, to make sure that even like music at mass, or there are so few priests and so few support staff that some of these contracts were for supplemental, musicians to play music at mass. That's gone in this contract cancellation. And then an interesting point I thought from Chris Motes, who's a friend of Napa Legals. He's senior counsel at First Liberty. He recently observed in a piece he wrote, I think for The Hill, about this issue that if these are being canceled in the name of fiscal responsibility, it kind of comes off as absurd because that's my language, not his, but he says the cost of these contracts is so negligible compared to other military expenses. So their cancellation, it's not neutral cost cutting. It's clearly you're targeting religious education, and he throws out a number that I think is pretty wild. Now obviously the Army needs weapons, they need missiles, they need, like, that's what they do in war, right? But it was just a wild figure. He said the cost of your average Catholic religious education coordinator under one of these contracts was $14,000, $15,000 a year. The cost of a single Army precision guided artillery round, one round is about $100,000. So for the cost of one artillery round, you could literally hire 6 of these religious education coordinators. So again, armies need artillery rounds, not knocking the military expenditures at all. But the money being saved on cutting Catholic educators and catechists is a drop in the bucket, a very small drop in the bucket of our military budget. So hopeful that some of this public attention that this is getting, coupled with the fact that it really is not a big cost saver, will put some public pressure on this, and we'll see at least a partial reversal to start to bring back some of these needed catechists on military bases.
Yeah, and something I'm seeing, again, like you said, military needs to spend money. This isn't a knock on the broader budget. This is, hey, the costs are so negligible of these religious assistants, basically, to the chaplain, that it's not really that much of a cost saver. And I think Chris Motz noted something really powerful of soldiers defend faith and freedom in America. Why would we kind of cut out their capability to protect that for themselves and their families? And I've seen some other comments out there about This is a situation that shows an example of why religious organizations can't depend on the government for any
Mhm.
assistance. And there is something to be said for that, right? Anytime you accept government money, there, whether kind of deliberate or not, there are strings attached. It's easy to become dependent on government funding. And like we see here, if it kind of gets cut out, what's there to stand on? And there is something to be said for that, but this is a bit of a unique situation
Mhm.
because, like Frank mentioned earlier, and Archbishop Berkeley has noted, sometimes this is the only option, right?
Yeah.
If you're a serviceman based in Syria, you're probably not going to be able to find a good Catholic catechist for your kids off base. There isn't really an option otherwise. So, regardless of that question of, yeah, should religious organizations be wary of government money? Whole another conversation. This is a bit of a special circumstance because there isn't really an alternative for a lot of servicemen and their families.
Yeah, no, that's a good point. It's not an applicable argument in this case, although it's legitimate in a lot of places, right? Because in other places you'll say, well, you're a religious school, don't take government money, raise money from your people, and then avoid the government strings. But what we're talking about here is a military chaplain calling. This is actually a branch of the government. This is not a private religious organization, right? Like obviously, the military archdiocese is a separate part of the church, but you have to work within the military structure to have chaplains. So it's just not the same situation. We don't have the ability to take like private dollars and have the archdiocese, spend resources it doesn't have and personnel that it doesn't have to send volunteer catechists to every military. It's just it's so closely entwined with U.S. government military operations that I agree with you. This is one of those places where you really can't take military money out of it. Yeah. All right. Well, with that, thank you for joining us for this episode of the Napa Legal Podcast. If you like what we're doing, we always appreciate it if you like and subscribe from YouTube, Spotify, wherever you're listening to. If you want to support the work that we are doing, we encourage you to go to napalegalinstitute.org, and you can do so there. So we hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and particularly the work of faith-based nonprofit organizations. Talk to you next week. Thank you, and God bless you.